Hey, Eric, thanks for joining me, buddy. How are you? Are you well?
I am well, Mark. I hope you are too.
Absolutely fine, mate. And for those of you watching this, this is going to be a great recording because the reason we're doing this is I wrote to CQC under a Freedom of Information request, and I've had a reply. And Eric has very kindly decided to jump on this video with me because he's got some points that he'd like to clarify in relation to the reply I've got. But before we go into that, for the few of you probably who don't know who Eric Baskind is, we're going to introduce Eric. Because Eric, I've known him for a very long time. He's not only a good friend, but he's a senior lecturer of law at Liverpool John Moores University. He's sat on numerous panels and he's done, I don't know, thousands of expert witness reports. But Eric, why don't you just give us a minute, buddy, and expand on what I've just said and, explain to people why you probably are more qualified than anyone else to talk about what we're going to talk about today.
Thanks, Mark. Gladly. So as you say, I'm a senior lecturer in law at Liverpool John Moores University. I'm also a consultant and expert witness in violence reduction and the safer use of force. I've been instructed in more than 3,000 cases, not only in this country, but also in other countries around the world. Many of those cases have involved very significant harm. Sadly, some of those have also involved the death, not only of the person being restrained, but I've had some cases as well which involved the death of the member of staff carrying out the restraint. I've appeared in numerous inquiries, including parliamentary inquiries, into the use of force in its very widest context.
Yeah, you've got some experience there. So what I'm going to do is I'm going to start off by actually showing you all the report that raised my concern. Then I'll show you the email that I sent to CQC, and then I'll show you their response. And then Eric, if you can kindly jump in after that and give your commentary on that, that would be really helpful.
Yeah, gladly.
Brilliant. Okay, I'm just going to share my screen. So this is the report that gave me cause for concern. It's the Sheffield Health and Social Care NHS Foundation Trust. And what I've done is I've put the word non-approved in a finder up here, and I'm going to click on that. And you'll see that in here, it says numerous times that staff had used non-approved restraint techniques. And if I click this forward, you'll see that this is actually written in this report 5 times. And my concern here is if they're talking about non-approved restraint techniques, then I'm presuming that CQC must have some idea of what an approved restraint is if something is, as they're commenting on here, being non-approved. So I wrote to CQC, and I'll now show you the email I sent them. So this is the email that I sent to CQC, and it says Freedom of Information request regarding Sheffield Health and Social Care NHS Foundation Trust. And it says, I read with interest the above report, which can be found here. And that's the report I've just shown you all. It says, in the report, it mentions non-approved restraint techniques 5 times. This therefore presupposes that there must be some form of approved restraint techniques and or approved systems of restraint. However, as far as I'm aware, there are no mandatory or government body appointed approved restraint techniques or approved systems of restraint. And I've been involved in the restraint industry for almost 30 years now as a trainer, consultant, expert witness. And I'll give them a link there where they can go and find out more about me if they wish. My concern is that if the CQC is signposting or advising trusts that they can only use certain systems of restraint or certain restraint techniques, that would be misleading, possibly discriminatory, as well as potentially having a negative impact on other businesses because, as mentioned above, no such mandatory systems or techniques exist. The result of this is that if a NHS trust adopted a system of restraint on the basis that it believed it was in some way approved, that would make the trust directly liable and CQC possibly vicariously liable if a trust felt under pressure to follow a CQC inspector's advice or insistence to use certain restraint techniques purely on the basis of some form of misguided or approved basis and a harm or death resulted that could have been prevented by using a different system, different restraint techniques or a different system of restraint. I also do not believe that it is within the CQC scope of competence to advise on what restraint training or restraint techniques should or should not be used, as that would legally be dictated by the trust's risk assessment in that area. That would surely be a conflict of interest. Therefore, could you please inform me, as a Freedom of Information request, of specifically what the CQC would consider to be 1. Approved restraint techniques and or systems of restraint, 2. What would constitute a non-approved restraint technique and or a system of restraint? And also, are CQC inspectors expected to advise on what restraint techniques or systems of restraint trusts must adopt? And if so, what competent training are CQC inspectors given in physical restraint, including duration and content? And how are CQC inspectors formally assessed as being competent to advise on all of the different systems of restraint used in NHS trusts? And as per the guidance, you have 20 working days, so on and so forth. And they replied. And this is their reply. It came in on Wednesday, the 20th of May, 2020. And it says, "Dear Mr. Dawes, I write in response to your correspondence of the 1st of May in which you asked the following information." And there are the questions there that I've just read out to you in the letter I sent to them. And they've considered and coordinated their response. And I'll take you through each response in turn. Here's my first question. Approved restraint techniques and or systems of restraint. CQC does not have a list of approved restraint techniques or systems of restraint. They do, however, point people towards NICE guidance, violence and aggression short-term management in mental health, health and community settings, NICE guidance NG10, as is available as best practice guidance. And they also, additionally here, they mention that NHS England is leading a significant improvement programme to reduce restrictive practices as part of this work. NHS England has commissioned the Restraint Reduction Network to develop standards, the Training Standards 2019, for the training, prevention and use of restrictive interventions. So that's their answer to question 1. So they do not have a list of approved restraint techniques or systems of restraint, and they're signposting to 2 documents here. My second question, what would constitute a non-approved restraint technique and or system of restraint? CQC does not have a list of approved restraint techniques or systems of restraint. The references in the report you quote from refer to Sheffield Health and Social Care NHS Foundation Trust's own policies for what are the providers, Sheffield Health and Social Care NHS Foundation Trust approved techniques. 3. Are CQC inspectors expected to advise on what restraint techniques or systems of restraint trust must adopt? CQC inspectors are not expected to advise providers about the restraint techniques providers should use, and CQC inspectors do not give advice about restraint techniques or systems of restraint. Question 4. What competent training are CQC inspectors given in physical restraint, including duration and content? And it says here, CQC inspectors do not undertake any physical restraint training. And the "and" goes on to my final question, was how are CQC inspectors formally assessed as being competent to advise on all the different systems of restraint used in NHS trusts? CQC inspectors do not receive training about the appropriateness of restraint training. And CQC inspectors do not give advice about restraint techniques or systems. And that's all very interesting, but it does give me cause for concern about something else. And it's this. This is Regulation 13, Safeguarding Service Users from Abuse and Improper Restraint. And you can see it comes from the Health and Social Care Act 2008, Regulated Activities, Regulations 2014, Regulation 13. And it says the intention of this regulation is to safeguard people who use services from suffering any form of abuse or improper treatment whilst receiving care and treatment. This is the interesting bit. Improper treatment includes discrimination or unlawful restraint. How can a CQC inspector determine whether a restraint has been unlawful or not if they don't get any training, are not expected to advise, and are classed, as the CQC have just shown us, as being not competent to do so?
Yeah.
So that's the basis of my concern, Eric. What do you think of that and the response?
Well, I think it really tells us quite a bit about what's happening. There are 2 issues here, aren't there? One is whether there is such thing as an approved technique, and by definition, therefore, an unapproved technique. And Mark, as you just pointed out from Regulation 13, it brings out the concept of unlawful restraint. Well, let's deal with those in that order. With the exception of the police service and the prison service, who've got their own systems and they are nationally accredited and nationally approved, there are no other standards which regulate and approve systems of physical intervention techniques. And that's really surprising because we all know that the use of force and the use of physical interventions is too high, and that a significant effort is needed to minimize the use of all types of coercive interventions, of course, including the use of physical restraint. So we must take that as a standard. But there are also circumstances, not only whereby it is necessary to use force, but also where it would be wrong not to use force in those certain circumstances. And we know that it's the use of force when it goes wrong, either the use of inappropriate techniques or the poor application of those techniques, that leads to significant harm. And we've seen that that harm can include the death of the person being restrained. And therefore, to me, it is just inexcusable that there is no standard system of physical intervention techniques which have been approved, just like the prison service and the police. It's gone through a system of legal approval, ethical approval. The techniques are efficacious, they are human rights based, they've been medically approved. And that forms then a syllabus, an overall basket of techniques which has gone through that rigorous system of approval from which organizations then choose. So if we take, for example, the police training manual, that's a huge manual involving a substantial number of techniques. Each of those techniques, each of those interventions, as I said, have been approved medically for the lawful application and for their effectiveness and so forth. And once they've been approved in that way, they then form this high-level manual of guidance. And that manual of guidance is for the use of chief officers. And it's a question for the chief officer based upon the risk assessment and the various categories of work that his or her officers have got to undertake to select those techniques which are appropriate in the circumstances. And Mark, to put that question the other way around, what it means is that no one in the police service can be trained in a technique unless it's been approved. So we've got that benchmark of standardization and approval. But outside of the police service and the prison service, we just don't have that. And that is just wrong, because we've got some systems which use really impressive and safe techniques. But I've come across, Mark, and you have, I'm sure as well, techniques from some providers that are just nonsense. They're dangerous, they don't work. And of course, if they don't work, by they don't work, I mean they're unlikely to work in operational setting. What it means is that staff will then have to resort to what they think is more appropriate. And that's when harm arises. And that's when things go seriously wrong. So why haven't we got this standard system? I've been in this game now for well over 35 years. And there has been a call for a standard method of physical intervention for as long as I can remember. And if we take perhaps more recently the 2013 annual Congress of the Royal College of Nursing, they had a call to lobby UK governments to review, to accredit, and then regulate national guidelines, which include guidelines for restraint. That went out to the Congress. 99.8% voted in favour. That was 470 members, and only one member voted against it. But what's happened? Nothing. There's been numerous meetings. I've sat on many of these meetings whereby all the right questions have been asked, and then it seems to just be forgotten about, almost as though at the end of it all, it's put into a box marked too difficult, and they decide that they won't implement it. And that is wrong. People are being harmed. People are dying as a result of this. And it isn't too difficult. It is really straightforward once we get round to an intention to do it.
Right. I mean, that's brilliant. Thanks for that. Now, one of the questions I've got here, I'm just looking at on my board here, it says that the response from CQC states that CQC will not advise on systems of restraint, etc. But if they do begin inspecting using the RRN standards, isn't this to agree exactly what they'll be doing? And isn't that a conflict of interest?
Well, the RRN standards are there to set in systems to minimize the use of all types of intervention, of course, including restraint. And as I said at the outset, that's got to be applauded. But they should have gone further. I mean, I remember at the very beginning of this, I had a meeting with Ben Higgins, the chief executive, and I urged him to make sure that those standards also included a benchmark for standardized techniques. We'll get together, we'll go through all of the approval methods that we've spoken about. That hasn't happened. So you can have an organization following the minimum standards set down by the Restraint Reduction Network and to be certificated by BILD, following that to the letter. And yet they might deploy certain techniques which are just either inefficacious or just plainly wrong. But if they don't contradict any of the standards, then they'll be allowed to use them. And that seems to me just to be wrong when we know we've got good techniques and we know we've got techniques which are pretty poor. Why don't we have a standard system? Without that, things are not going to improve at all. And they also signposted you, Mark, to NICE NG10. Well, that's a really helpful document, and that's cited quite frequently. But what people also need to know, and I was fortunate enough to be invited to be the independent expert for the High Secure Manual Steering Group. That was chaired by Pete Turner from Broadmoor. And that was a new suite of training manuals for the 4 UK high secure hospitals. So Broadmoor, Ashworth, Rampton, and the State Hospital at Carstairs in Scotland. But what people need to know as well is that then, after we produced that, that then received endorsement from NICE. So we've also got something from the National Institute endorsing a suite of manuals, and yet we still haven't got anything that is formally approved. And that, in my view, has got to be the next biggest amount of work, the next biggest task that a regulator needs to pick up on and put into operation.
But, you know, going by CQC's response, if the inspectors are not given any training, are not competent in physical restraint, they can't advise on physical restraint, and Regulation 13 says they've got to make sure that no unlawful restraint is taking place.
Yeah.
How are they meant to do that? It's just going to be subjective, surely.
Yeah. Well, it's going to be subjective, and that's just not acceptable. The use of interventions, the use of restraint is a really complex matter, and it involves so many different aspects to make sure that what's being done is absolutely appropriate in all of the circumstances. If you are not trained and trained to a reasonable standard, it just defeats me how anyone could be inspecting a service. And we know, Mark, I've certainly had the inspectors who've contacted me and asked for my views when they've gone into a service as to what they should be looking for, as to whether something should be allowed or whether it shouldn't be. They shouldn't be asking me. They're the inspectors. They ought to be able to have the capability and the competence to be able to inspect properly in such a difficult area. And it's an important area. It's an area that if it goes wrong, harm, not only just the physical harm that I've referred to just before, but also a significant amount of psychological harm to the service user, to the patient, as well as to members of staff. And people often forget that staff can be harmed when they have to use interventions. That's got to be something that the CQC have got to pick up on. If they're going to inspect, then they need to be competent to do so.
Yeah, I want to pick up on a point you mentioned actually about, restraint being a very complex area. I don't think people actually understand that. I've been in this industry for 30 years. You've been in it for longer. And I think there's a perception by certain people, certainly in certain organizations, that think restraint is just a bunch of people that want to use a range of techniques, and it's as simple as that, teaching them mechanics, and they'll go away and do it. There's a whole plethora of stuff that's got to go with that in terms of understanding when and how to apply the techniques, demographics, working out risk assessments, training needs analysis, all the things that go with that. And just leaving out a technique, for example, and saying we don't like that one because it's bad. That's very, very short-sighted. It's very naive, and they're not looking at these things holistically. So that's a really good point you made. One of the questions I've got, or another question is, who would be liable then if they were advised by a CQC inspector? Because, and I'm asking this question because in the response to me, they are signposting me to the 2 documents, the NICE NG10 document and also to the RRN standards. So who would be liable then if they were advised by a CQC inspector to use a training provider on the BILD Act list and something went wrong? Would it be CQC? Would it be BILD? Or would it be the organisation?
Well, most certainly it would be the organisation, because they have the legal responsibility, and no doubt if something went wrong, and presumably if something goes wrong, we're talking about someone being seriously harmed, or someone being harmed, or who dies as a result of the intervention. There's no doubt that the organisation itself will be liable. Now, depending upon the circumstances, you can imagine the lawyers will then look to see if they can apportion blame elsewhere. But Mark, we've got examples of this. Not so long ago, we had the case of Derek Lovegrove. He was a poor man with severe mental health problems that manifested in significant amounts of violence and aggression, including self-harm. He was originally detained in the high secure hospital at Rampton. And then he was moved to the Cedar Vale secure hospital. Now, Cedar Vale used a system of restraint called MAPA. And what happened was that there was an inspection from the Healthcare Commission, and they were advised to move over to a different system. So it happens to be the MABO system. And following that advice, they moved over to the MABO system. And not long after that, there were some concerns from staff that it just wasn't adequate. It couldn't deal with the complexities that they had to deal with on a regular basis. So the experts in MABO went in, and it transpired that the staff were not being trained properly. They weren't implementing the techniques from MABO that they ought to have been implementing. So there was a lot of confusion as to the standards that they were using for the physical intervention techniques themselves. As a result, unfortunately, Derek Lovegrove died under restraint, and that led to a prosecution from the Health and Safety Executive. And in the Nottingham Crown Court, because of course this is a criminal matter, the healthcare provider was fined £100,000 for breaches of sections 2.1 and 3.1 of the Health and Safety at Work Act. So there's just an example of where something goes wrong, and there you've got the liability. Now, of course, what we don't know is what went on behind the scenes, and I'm sure a question was asked, well, why did the Healthcare Commission recommend that they went from one system to another? Particularly when it turned out that it was unjustified, but particularly when after the event, staff were concerned about that change. What would have happened had they kept to the original system that presumably was tried and tested? So there's an example of liability, and there's no reason to suggest that same principle wouldn't apply again.
Yeah, and going back to the signposting to the BILD Act, the RRN standards, etc. Those standards, that certification scheme takes you through all the paperwork exercise, as we've already discussed. But when it gets to the techniques, they're not actually going to be checking on the techniques. And one of the questions that I've got is even if they do send people out to inspect people against the standards from BILD or the RRN, whoever, how are they going to evidence the competence that the people have to go and actually assess whether techniques are fit for purpose or not?
Well, they do go out and they do inspect in terms of the BILD certification process. But let's just think of an example. Let's take an example of a training provider. Let's take this training provider as being an excellent training provider that's been around for many years. They are accredited themselves via their own awarding organization. They fully support principles of restraint reduction, but for their own reasons, they've chosen not to be certificated under the BILD scheme. What that means is that training provider, as things stand currently, cannot be used by a trust under the standard NHS contract. What the trust has got to do is they've now got to choose another training provider who is BILD certificated or going through the BILD certification process. And that's not satisfactory. I've had numerous conversations with organizations who have said that they really want to stay with a current training provider, but that training provider isn't willing to go down the BILD route. But they're not happy with the techniques that they've been told that they've now got to follow with their new provider. And my initial response would be to them, well, go back to your new provider and tell them these are the difficulties you've got, not too dissimilar from the Derek Lovegrove issue at Cedar Vale, and ask them for their guidance. They've asked them for their guidance and come back and said, well, we can't really help you any further. And that just seems to me to be a significant defect in the system, one that's easily remediable, but a significant defect nonetheless.
Yeah, my understanding of it is that if you teach any form of prone or face down, or, God forbid the words pain compliance techniques, you can't get accredited under or certificated under the new scheme. Is that correct?
Well, initially, there was an almost blanket ban on prone, restraint, and pain compliance interventions. But that was watered down with pressure from a number of organizations. And just pausing there for a moment, why did it need pressure? If they really understood the issues, they wouldn't have banned them in the first place. But there is still a substantial dislike for them. We know that the majority of interventions don't require pain compliance, and you can deal with the situation perfectly safely and properly without any question of there being a ground restraint, let alone even talking about whether the patient should be prone or supine. But in very limited circumstances, it could be a matter of life or death. It could really be a matter of safety to use interventions such as pain compliance techniques, such as the appropriate use of prone restraints. And again, there's huge amounts of confusion. And don't forget that the whole argument about prone restraint came about or really hit the focus in the UK following the Winterbourne View fiasco. And the serious incident report following that made a number of recommendations. One of the recommendations was that we're not minded to impose a ban on any intervention. But if we were, then we would seek to ban supine or a type of supine restraint. That then comes into policy as a ban on prone. And it really is totally confusing how you can have the serious investigation suggesting a ban on X, and yet when the guidelines come out, it seems to ban Y. And we know with prone restraint that there is a safer way of doing it. There is a dangerous way of doing it. Done properly, it has a place in the limited circumstances whereby it's needed, and exactly the same with pain compliance. But what's now happened with the restraint reduction network standards is that they've now introduced something which they refer to as an emergency intervention. And rather than sort of standing up to what these techniques are, calling it what they are, and let's have a proper debate about them, they're now referred to as emergency interventions, so almost hiding it. But that takes us back, Mark. You'll remember the very sad case of Adam Rickwood.
Yeah.
Adam Rickwood took his own life in an institution some years ago. And the big issue there was that the staff were using a technique which was known as a distraction technique. And the distraction technique was this technique here, whereby you attack the nose. So you attack the person's nose quite forcefully. I'm sure it will cause a distraction, but quite forcefully. In that particular case, the inquiry showed that there were a number of people who were a number of young people who were severely injured, Adam Rickwood being one of them, and sadly, he took his own life. Now, my objection to this is, let's call this technique exactly what it is. Let's not call it a distraction technique, because if I say to you, I just merely used a distraction technique, you'd probably pat me on the back and say, well done for not using anything more forceful. But if I said, well, actually, what this distraction technique was a karate chop under the nose, which causes a significant amount of harm and typically would cause a lot of blood flow, you'd say, why did you do that? So let's call these techniques what they are, and let's have a proper debate about them. And that's what's wrong with not calling the prone technique a prone restraint intervention and pain compliance. If we're calling them emergency interventions, and I know a number of organisations that now don't record prone or pain compliance. There is no process on the forms for recording it. They've got to be recorded as emergency or rescue techniques. So when the question is asked, when audits are done and the question is asked, Mark, how many restraint techniques have involved pain compliance or have involved the use of prone restraint, that organization or the managers can look through the records and say, none. Why? Well, because they're not recorded. There is nowhere to record them. And that is just wrong. Let's call them what they are. Let's record them accurately, and then let's have a proper debate about them.
Well, you mentioned, what did you call them? Emergency escape techniques, sorry.
Yeah, emergency and rescue or escape techniques. They're referred to variously by those techniques.
Well, if I was working with an organisation and I put my audit hat on and I went in and said, let's have a look at what you've got and see where you want to get to. And they say, right, well, in the last month, we've had 12 emergency rescue or emergency intervention techniques. I'll say, okay, in the same area with the same people. But, well, hang on. After the first one, surely you must be planning your interventions. They can't all be emergencies.
Yeah.
And I know when I'm lecturing sometimes, I talk about the difference between exceptional and extreme. And people don't understand the difference with that. And I say, well, look, when you get something that's extreme, you can plan for it.
Yeah.
So you get extreme weather warnings, for example. They'll say, it's going to be thundery tomorrow. There's an extreme weather warnings. You can plan for it. But then something might happen where the extreme weather doesn't happen and the sun comes out, and it's an exception to the norm. I said, so you're always going to have an exception, which you can't plan for, but you have extremes which you can plan for. So if I was auditing and they said, well, hang on, we've got all these extreme circumstances, extreme emergency rescue techniques, any auditor or any inspector that should know their salt would say, hang on, if after the first one, why isn't this being planned? And why isn't your extreme shifted? And why aren't you managing that better? Well, and by doing that, you can reduce restraint properly.
Yeah, Mark, and that leads on to another question. So in all of the cases that I'm instructed as an expert, I will get the use of force forms. So these are the forms that staff will complete after they've used force on a person. And surely the first question I want to know is, well, what did they do? And when I see, and I do see it now, and it's increasing, when I see intervention used, an emergency or a rescue technique, well, that doesn't help me. What is it? So, and you can't provide training needs analysis if you don't know what the intervention is. So there's many techniques that are taught. I mean, you remember going back to your days in the prison service, techniques such as the inward rotation and the outward rotation. Yeah. Those are frequently taught. But if you ask yourself the question, are they ever used? Almost certainly they're not used. And when they are attempted, they invariably don't work. There are better things now. And yet they're still taught. But if you do a proper training needs analysis, and if you do a proper assessment of the risk and speak to the people on the ground, you will realize that you can save a significant amount of time and harm, because these are pretty painful techniques, not only in practice, when you're in the gymnasium practicing these techniques. Let's get rid of them. Save the time for doing things that are proper. So calling things that are just unhelpful, or calling them something that is just a blanket description that doesn't tell you what they are, is really unhelpful and doesn't take the debate very much further at all.
And it's not going to stand up to scrutiny in court, is it?
Well, it wouldn't. It wouldn't at all. And the question that I ask when I get a use of force form, and it says, an emergency rescue technique, for example, I want to know what that is. And of course, I can't be told because the organisation now doesn't know, except when they go back to the member of staff, and then I get the answer, the proper answer. Well, if there is a proper answer, of course there is, because the staff know what they've done. Why can't they put the techniques down and call them what they are in the proper way? And if we are looking to see how many pain compliance techniques have been used, the only answer to that is by recording them. Because what will happen now is that we will see where an organization has got a use of force form, whereby there is no way you can tick box for pain compliance, you'll have to call it something else, then the use of force reporting mechanisms showing how many pain compliance techniques, for example, will be significantly reduced, when in practice they haven't been. They're just not being recorded, and that's not right.
No, and if people are, allegedly being told not to record this stuff, isn't that fraud?
You've got to ask yourself the reason why they're not being allowed to record that properly. There is a drive to reduce the number of pain compliance techniques. Of course there is, and that makes perfect sense. Equally, there's a drive to reduce the use of all types of interventions and restraints. But if you hide it under the carpet by not recording it, that's pretty sad.
Yeah, no, it's absolutely crazy. Okay, one other question I've got for you is many care providers, their main concern is cost and compliance. That's the main thing as care do. So, outside the NHS, we have care as well. So if they've been actively signposted to the RN standards by CQC, many will possibly see that as a must-have when this is not the case, because obviously they want to keep the inspectors happy and they don't want to have any sanctions imposed on them. So what's your view on that?
Well, although it's been delayed, and I think it's been delayed again because of the COVID pandemic, there is an expectation and a requirement that people operating under a standard NHS contract have got to either have a training provider that is certificated under the BILD RRN system.
But that's for the NHS.
That's for the NHS.
What about care homes?
If they're not operating under the standard NHS contract, then it doesn't apply. What you will find, and I've certainly come across this, is that a number of organisations, although not legally bound by the standard NHS contract and its conditions, will want to voluntarily use the system and follow the same process. And that makes perfect sense to me if the process is right. But and the example I gave you before, you can have many, and I've come across many, Mark. Yours is a really good example of it. An excellent training provider, properly accredited by people who know what they're doing, have stood the test of time over the years. Don't want to go down the BILD or the restraint reduction network process, but nevertheless follow the principles admirably in wishing to reduce all types of coercive interventions. And yet an organization won't be able to use your services, but they'll have to use another one, even if they're not particularly happy in using that other one. To me, that system can't be right.
No, I appreciate the things you said there, but for me, it was an easy decision. I don't have, I'll be absolutely honest, I don't know if it's moved on, but from when it came out, I had no faith in it. I'm not going to be dictated to about what techniques we can and can't use if that's not in the best interest of the organisation, the service users and the staff, because we're all about reducing restraint, reducing injuries. And I personally, for me, I couldn't stand in front of people and tell them something to do something that I didn't believe in, because I've given a guarantee ever since I've been in this industry that if you need me, I'll come. And that's got me into court with people. I've helped people with investigations in tribunals. And in the vast majority of cases, when we've explained why, the investigation has gone away because we've been there to support them. I just didn't feel if we signed up for this scheme that I'd be able to do that with 100% total confidence. But that's a side issue. That's just my issue.
Mark, I've not come across anyone who isn't in favour of a huge drive to minimize the use of all of these types of coercive interventions. I mean, everyone, quite rightly, not just in this country, but around the world, has got to be in favor of that. We know, don't we? No matter what the setting is, if you've got staff A, B, and C who are working that day or who are on duty, there'll be a lot more interventions than when you've got C, D, and E, or D, E, and F working. And if you ask yourself the reason why, we know that interventions can be minimized. So with that in mind, there's a lot of good things to be said about the network and a lot of good things to be said about wanting and imposing restrictions on the use of force in its general sense. But Mark, my criticism, my main objection is, and it's sad, it's a missed opportunity, because they could have done it so much better if they'd have gone outside of their own circle and engaged properly. And if they'd have engaged properly, they will have heard views perhaps they don't want to hear. I've had numerous meetings with them. I know colleagues have had numerous meetings with them, and they're slowly and surely changing those guidelines and the standards. So, for example, if you look at the very original discussions on pain-complaince and prone restraint, just to use that as an example and look at how they are recorded now, you'll see a huge difference. But there's a lot more that needs to be done. And one of the things that needs to be done is an acknowledgement of standardized techniques that have gone through all of the processes, and then they could be properly certificated and accredited.
Mm. And now we're at a point now, just going full circle on this, where we've got the standards, and at the moment they're not mandatory, are they? Because there's been no guidance issued by the Secretary of State for Health.
No, but that is a process that could come, and in my view will come. I think everything has been derailed with the pandemic that we're all suffering, but I think that will come in due course.
We're going back to this, so whether that comes or whether it doesn't, we've got these standards, but we now have inspectors who've got to inspect against the standards that are getting no training, no real guidance, and a CQC's thing of CQC's response already shows, they're not supposed to be advising or mentioning what systems they use, but they're signposting to the RN standards. And that concerns me, because how can an inspector, going back to the basics of this conversation, under Regulation 13, where they have to make a decision about whether force used was unlawful or not, at that basic level, how can they do that if they're not getting the training and the resources, the information?
Well, it's not just the Regulation 13 point, Mark, about whether the restraint is unlawful, but it's also the basic premise of your questions under the Freedom of Information Act request that you made, whether there are approved techniques and whether there are unapproved techniques. For an inspector to go out and inspect to make sure things are working properly and safely for everyone concerned, they've got to understand pretty significantly what the issues are. And if they're not trained, and we know they're not trained, then how can they properly inspect?
I think the point as well is this is not just a CQC issue. I've had this with Ofsted in the past as well. I've actually written to Ofsted and had the same responses. I think they sit and watch a PowerPoint presentation for a couple of hours, currently I'm advising someone who's got an issue with the Social Services Department because they've taken a child on, and they were really pressurizing taking the child on. And these are really good people. And the child's got very complex needs, and they've done great work with the child, done phenomenal stuff. But there's one particular thing where the child will grab staff in a certain way, and the only way they can get a child to release is to use a thumb distraction technique, which is a pain-complaince technique, and they've been quite open and transparent about it. And the inspectors have said, no, we don't like the fact you're using a pain-complaince technique. And they've explained all the reasonings why. They've even sought legal advice and expert advice and risk assessed it and done all the behavioural care planning. And if they weren't doing what they were doing, this child would end up in a secure home. No two ways about it. But the inspectors are saying, no, you can't use that technique because the use of force that causes pain with the child is illegal. And you and I both know that that's absolutely not true. I wrote to a barrister on this when I was invited to the Independent Restraint Advisory Panel, when they made the comment that any force that caused pain with the child was illegal. I challenged the chair of that panel, and I got a barrister to issue a letter to that effect. So we know it's not true, but it's quite sad that there are people in positions of influence out there who have this misplaced knowledge, and it's if I was to, and I'll probably follow this up with a session on HSG 48, because it is a latent failure, it's rule-based and a knowledge mistake.
Just in case there is anyone watching this podcast who doesn't get it, let me just give you an example. Let's say, and you use the example of children, I'm going to keep to this. So we've got in a young offender institution, for example, or a secure children's home, you've got a person classed as a child. but this person is extremely violent. And let's say that this person is attacking either a member of staff or another child. And let's describe this this attack. Let's say they've got them around the neck and they're choking them, and the victim is getting pretty close to losing consciousness. Member of staff comes and they use the various techniques that they've been taught, which are non-pain compliance, and they're getting nowhere. This is a very powerful, violent child, and they're getting nowhere. Are you telling me that it would be wrong for that member of staff not to use a thumb hold or a small finger hold to be able to cause an immediate distraction with pain to release and save the life of that child? If anyone suggests that that would be wrong, then someone needs a proper look at what's going on.
Well, I actually had a case, and this is probably going on a bit, but it doesn't matter, it's important. Years ago in a hospital where they had a child come in that had a head injury, and they had to sedate the child to suture the wound. And the child was put on the 4th floor, where there was a children's unit on the 4th floor in a city hospital. And he woke up, and the child, I think he had a learning disability as far as I remember, but he was very confused and very scared and very frightened. And he ran to the window and was banging at the window to try and get out. And it was an old hospital, and the window restrictors broke. And he was a very powerful young man. And he tried to climb out the window, not knowing where he was or anything. And if he'd have fallen 4 floors, he'd have, invariably be dead. So the 2 nursing staff, with no training whatsoever, grabbed hold of him, basically rugby tackled him, pulled him back in, and he fell back. And I think his arm hit a bedpost or a radiator, I can't remember, but they fractured a bone in his arm. Both nurses were suspended for causing harm to a child on the basis that any force that they use that causes pain or injury is illegal. And they were looking to send their names for inclusion on a list. And it was purely perchance the hospital found me, and I went and had a look at this, and we raised the point, we had to give them a basic lecture on what reasonable force meant. And when they got that, I actually said, look, if you discipline these staff for that, I said, you're leaving yourself wide open to a whole raft of legal action and litigation. And I'm glad to say, the nurses were found not, innocent of any wrongdoing, as they rightly should have been. But it just gets me that, there's people in positions of influence, management positions, inspectorate positions, who are making these subjective decisions without any knowledge base to it at all.
Yeah. Well, that's right. And because they don't understand the issues, they can't get beyond the simple question, is it ever right to inflict pain on someone? Well, whenever you ask a question like that, you're bound to get the problem. But there are certain circumstances. You've given an example. I gave an example in that hypothetical example of the child throttling another child. There are many, many examples. But as long as we don't give the wrong impression that these are standard techniques that are just freely used, they're not, and they shouldn't be. But there are certain types of emergency situation where their use is appropriate.
Well, I think you're right. And, but going back to the inspector's point, it's something that keeps flashing in my head with this. Is if I was a young man again and I was going for my driving test and I sat in the car at the test centre, and the instructor got in the car, he said, I'm your instructor today, Mr. Dawes, and I'm going to be taking you through your driving exam. I say, great, because I'm keen to pass my exam because I want to start driving on my own. And if he said, oh, just 1 point, I actually don't drive myself, I've never passed my test.
Yeah.
I'd be thinking, how can you assess me? It's frightening. And I think this is the reality.
And is there a difference, Mark, between that and an inspector in any area, an inspector not being properly trained and therefore not understanding what it is that they're inspecting, particularly something as complex as the use of physical force?
Not in my eyes. No.
Nor in mine.
No. All right, my friend. Thank you ever so much for your time today. Is there anything you want to add or say before we go?
No, my pleasure. Good to see you.
Yeah. No, that's great. And I think I may have to challenge you to do another one of these, because I'm pretty sure when this goes out, there'll be a lot of questions coming my way or a lot of comments put on the threads below wherever we post this stuff. So we may have to do a follow-up.
Look forward to it.
All right, Eric. Thanks ever so much, mate.
Bye.
Take care. Bye-bye.